And a very good morning to you. This is John Fradgley from the Bell Legal Group, back with you for another program of The Law and You. That's right, it's Tuesday morning and your opportunity to get free legal advice between now and 9:30. All we'd like you to do is get on that telephone as soon as you can. 55208888 is the number. That number again, 55208888. Don't forget, if you're not able to get to the phone but would still like to put a question through to be answered, you can always use our email talkback, or our talkback email, I should say, and the address for that is talkback@4crb.com. So you can either call us on 55208888 or use that email address, talkback@4crb.com. Don't forget, if you're south of the Tweed River, you need to put 07 in front of our number, otherwise you'll get straight through if you're calling from Tweed or throughout Queensland. Thank you to the people who called in last week. Certainly a few varied and interesting questions arose. One which did arise, you may recall, was Brad, who called about powers of attorney in New South Wales. And we were talking about the difference between how powers of attorney are entered into in New South Wales as opposed to Queensland. In Queensland, of course, we only use one document, and that is the enduring power of attorney, which covers both financial as well as personal and health matters, whereas in New South Wales there are two separate forms. So you have the enduring power of attorney form, which is for financial matters, but if you want to have matters in relation to your health dealt with, then you need to also complete the appointment of an enduring guardian. Now, the question that arose, of course, was whether the enduring guardian in New South Wales has immediate effect, because Brad's question was around an appointed power of attorney in New South Wales trying to cancel doctor's appointments for some friend of his. And I pointed out that in Queensland, the enduring power of attorney, particularly in relation to health matters, only takes effect when the donor of the power of attorney loses capacity. So in other words, whilst the attorney has capacity, while the donor, has capacity, the attorney has no right to make any decisions in relation to health matters. And what I wasn't sure of last week was whether it was similar in New South Wales. I was fairly confident it was the same, but I said to Brad I wanted to check on that question and that I would comment this week. And sure enough, it is the same. So in New South Wales, with the appointment of an enduring guardian, that appointment will only take effect when the donor of the power of that enduring guardianship loses capacity. So in Brad's particular case, the attorney down there has absolutely no right to be cancelling doctor's appointments or doing anything in relation to the medical affairs of the donor of the power of attorney whilst that person has capacity. So that's just something to bear in mind. Just a little bit of a reminder too at this stage, and that is in relation to enduring powers of attorney generally, that in relation to financial matters, you can elect under the power of attorney when the power of attorney will take effect. The overwhelming majority of people, when appointing an attorney, will provide that the power of attorney takes effect immediately. However, there are some people who want the power of attorney to say that the financial power of attorney will only take effect when they lose capacity. And of course, in those circumstances, in order to use the power of attorney, then you would need to get a letter from a doctor so that anyone dealing with the attorney is satisfied that the donor has in fact lost capacity, and therefore the attorney is lawfully able to use the power of attorney. I generally don't recommend that people provide in their power of attorney that it will only take effect when they lose capacity. I believe that it is better to say that it will take effect immediately, and that's because if, for example, you were to go overseas on a holiday and you needed the power of attorney to be used to sign some document for you while you're away, if your power of attorney says that it only takes effect when you lose capacity, well, obviously the attorney is not going to be able to sign that document for you while you're overseas. And so therefore there are inconveniences in doing that. The other one, of course, is that if there is some some urgent need to use the power of attorney after someone loses capacity, until you get the doctor's report to satisfy anyone you're dealing with, there will be delay, and sometimes it may perhaps take a week to get that doctor's report, and in those circumstances it may be that something critical needed to be done but couldn't be done because the terms of the power of attorney precluded that from occurring. So, Brad, I hope that answers your question, and that you will be able to speak to the person who's granted that power of attorney. And as I said, if they still have capacity, the obvious thing for them to do, if they're not happy with the way the person holding the power of attorney is dealing with it, would be to revoke the existing power of attorney and to make a new power of attorney. But enough of that. We need some calls. The lines are presently free, so if you have a question or a query, get on that telephone straight away. Our number, of course, 55208888. That number again, 55208888. And we'll be back after this word from our sponsor.
At the Hillview Aged Care Open Day on Wednesday, October 2nd, you'll learn how Hillview's premium aged care communities can make you feel right at home. Meet Hillview's aged care team, tour the Merrimack community and get a taste for life at Hillview with chef-prepared food and fun lifestyle activities. Our sponsor Hillview Care's Merrimack Open Day is on Wednesday the 2nd of October from 9 till 12. To find out more, visit hillviewcare.com.au or call 5559 3222.
8 days of Smeg deals and bonuses now at Harvey Norman. Get up to 10% cashback on Smeg Classic and Victoria Series cooking appliances. Plus, buy any Smeg induction cooktop and receive bonus cookware. Plus, exclusive to Harvey Norman, spend $1,500 or more on selected Smeg products and receive up to $1,000 as an FBOSS gift card. Bonus by redemption. Conditions apply. See store for details. Now's the time to buy Smeg at Harvey Norman. Hurry. Offers end September 26.
Go, Harvey, go.
Our sponsor.
And this is the Law and You on 4CRB, our telephone number 55208888. If you have a question or a query, you can call straight away because you will actually be our very first caller. So 55208888. Please don't leave those calls to the last few minutes of the program. Last week we had a very slow start and then all of a sudden a barrage of calls that came through towards the end of the program, which makes it difficult, and sometimes it's necessary to take some of those calls off air after the program has finished, which I prefer not to do because in answering your query, I may not only help you in relation to the question that you have, but it may also help someone else out there who's listening to the program but doesn't have the capacity at the time to get to the phone and is just listening in. So please don't forget to get on that telephone as soon as you possibly can. 55208888 is the number. Just a reminder too that there are only 92 days to Christmas, and you may recall last week I mentioned that there is a change in the law coming through in relation to gift cards, which will apply from the 1st of November this year, such that all gift cards will be required to have a life of at least 3 years from the date they're purchased. So if you're thinking about buying a gift card for a loved one as a Christmas present, make sure you leave it until after the 1st of November because that way you'll be able to ensure that you get ones that have a life of 3 years rather than those that are issued by many companies at the moment that normally only have a life of 12 months. And just a reminder too that Woolworths and Bunnings already have unlimited gift cards. So if you buy a gift card from Woolworths or Bunnings, they have no expiry date. But enough of that. We've got our very first caller on the phone. As we say, a very good morning to Ivan. G'day, Ivan. How are you?
Oh, good morning, John. You've probably heard this one before. I've got trees hanging, branches hanging over my property.
Mm-hmm.
I want to cut those down. Do I have to let the neighbour know that I'm going to cut them down, or and am I legally allowed to cut the trees on my boundary?
You're certainly allowed to cut the trees back to the boundary.
Yep.
So what I would recommend that you do, though, Ivan, I think it's just a matter of courtesy to let the neighbour know that you're intending to do that. And even if it's just simply down to putting a note in their letterbox and just saying, "Dear neighbour, just wanted to let you know that I'm going to be trimming the trees on the boundary back to the boundary line on, maybe a date in 7 days' time, something like that, and just wanted to let you know as a courtesy in case you have any questions or concerns. But certainly under the law, you're entitled to cut the trees back to the boundary. And the other neighbourly thing I think to do too is to also, in cutting the trees back, not only to obviously do a reasonable job of it, but also to take the branches away and dispose of them yourself rather than, I don't know whether under the new legislation it's still the case, but certainly under the old Act, under the old Dividing Fences Act, there was actually a requirement to pass the branches back to the neighbour, and that used to cause a lot of problems when people would trim trees back and then throw the branches over the fence. I think that's a fairly unnecessary and unneighbourly thing to do. So if you're going to be cutting the trees back, as I say, just approach the neighbour in the first instance.
I've got no problem cutting the branches away, but I don't get on with the neighbour. So
I'd just put a note in the letterbox then, just in their letterbox saying, "Dear neighbour, just as a matter of courtesy, I'm letting you know that I'm going to be trimming the trees back on whatever date." But certainly you have a right to do that under the law.
All right. Thank you, John.
Okay, Ivan, all the very best. Time on 4CRB is just coming up to 17 minutes past 9. The Law and You is the program. 55208888 is the telephone number if you have a question or a query, just like Bill. G'day, Bill. How are you today?
I'm well, thank you.
That's good. How can I help you today?
Legal capacity. Who decides? Is it the GP or the geriatrician that has to decide whether one has legal capacity or not?
Well, it depends, Bill. If a person, for example, if I was going to, needed to have a letter to confirm I had legal capacity, in the first instance, you would always go to your GP, because your GP knows you the best and, is able to easily provide a letter saying whether you have capacity. If, however, there are doubts about your capacity, then the GP may then refer you to a geriatrician to make the assessment. And over the years, I've had that instance where we've been looking at making a will or a power of attorney for someone, and we have concerns about their capacity. So in the first instance, we ask them to go to their doctor and get a report from the doctor. In certain instances, fairly rare, but I can remember at least 2 or 3 where the GP has said, "Look, I'm not really comfortable. I'm not totally satisfied that Mrs. Brown has got capacity, and therefore I'm going to refer her to Dr. Jones, who's a specialist geriatrician, to make the assessment."
Right. Now, and the other question concerning legal capacity, somebody with Alzheimer's disease who has been deemed not to have legal capacity by the doctor, how, in dealing with banks, how does one go about that? Because recently a close friend of mine who doesn't have legal capacity anymore was about to give all her information to one of these scammers on the phone, and her daughter went, and fortunately the daughter got there in time, went to the bank to say, "Look, I'd like to close Mum's accounts and put them all in term deposits," or something like that. And the bank said, "No, the patient, your mother has to come in with you."
Right. Well, the banks are getting very touchy about how they deal with the bank accounts of the elderly, particularly since the Royal Commission into elder abuse. And so therefore I have had instances myself where I act as attorney for clients, and certain of the banks have said, that they require the person to come in with you. The first thing, of course, that the daughter would need in those circumstances is a power of attorney. So if they don't have power of attorney for their mother...
she has enduring power of attorney.
Okay, so if she has enduring power of attorney, what I would... does she have a letter which says that the mother doesn't have capacity?
No.
All right. Well, I would suggest that she get a letter from her mother's GP saying that this lady does not have capacity. And if she took that letter together with the power of attorney into the bank, then I think that the bank would then act upon her instructions. because what the banks are really concerned about is that people have money taken off them. So it's not just the scammers on the phone and the Nigerian email scams and all that sort of thing. It's also, sadly, often relatives who are abusing their parents or the donor of the power of attorney by taking money or otherwise dealing with assets that they have no right to deal with. That's why the banks are so touchy. So in your friend's case, what I would suggest might be the best idea would be to get the certificate off the doctor. She could, in the first instance, take her mother in with her and see if they'll act immediately, because obviously the last thing you want to have happen is that the mother gives away information which enables someone to access her bank accounts.
Yes.
But, so that might be the first instance, but I think in the long term what your friend would be better to do would be to get a certificate off a doctor as soon as possible, confirming that the mother doesn't have capacity, and then to have the power of attorney registered with the bank. So that just means you take the power of attorney in, the original. The bank will take a copy of the original document and confirm that they've got it, and they'll record you as the attorney, or they'll record the person as the attorney against the bank accounts of the donor of that particular power of attorney.
Oh, well, thank you very much for that.
Okay, so I hope that's of some help, Bill. No trouble at all.
You.
All the very best. Well, the time on 4CRB has just passed 22 minutes past 9. The Law and You is the program, 55208888, the number. A very slow morning this morning. There was an avalanche of calls on the switchboard at about 10 to 9, which we thought were all coming through for the Law and You, but apparently not. So it's a quiet morning. Perhaps it has something to do with the school holidays at the moment. But if you have a question or a query, get on that telephone right now, 55208888. We'll be back after this word from our sponsor.
Are you serious about losing weight? Vitadiet has been helping Australians lose weight and live healthier since 1987. All Vitadiet shakes, soups, bars and desserts are gluten-free, made in Australia, and have been perfected over 30 years. There is a Vitadiet eating plan, and yes, you do eat real food. Plus, use the Vitadiet ketone sticks to gauge your fat-burning performance. To find out how you could lose up to 3 kilos in your first week, visit vitadiet.com.au for your local pharmacy or call 1300 Shakes. Vitadiet. Time to try it.
A sponsor.
Hi, this is Josh Mashman from Retirement Planning Partners. Are you concerned about your superannuation or investments? We are living in worrying times where we are constantly hearing of Brexit or trade wars between the US and China. But don't worry, soon I will be conducting a special seminar with my colleague and SMSF specialist John Lomas, which will show attendees how to create financial security and independence through sensible investing. To register for this free seminar and learn how to build a successful retirement portfolio, phone 5593 0005 or visit our website rppartners.com.au.
Retirement Planning Partners is a corporate authorised representative of Madison Financial Group, AFSL number 246679.
And the time is 24 minutes past 9. This is 4CRB. The Law and You is the program, and you can get some free legal advice, but only in the next 5 minutes or so. 55208888 is the number if you have a question or a query. 55208888. Just going back to the comments I was making about the question last week from Brad about when enduring guardianships take effect, and the comments I was making about powers of attorney generally. Tommy, who's operating the console here for me today, raised a question during one of the sponsor breaks about conflict of interest, where, for example, you've got a financial power of attorney which has immediate effect. What about if there's a conflict between what the donor of the power of attorney wants to do and the attorney wants to do? Well, there are a couple of things there. Firstly, conflict transactions can only happen if the power of attorney specifically allows them. And obviously you're not going to appoint someone as your attorney if they're going to be in conflict with you whilst you still have capacity. But enough of that. We've got a couple of callers online. As we say, a very good morning to Robin. G'day, Robin. How are you today?
Oh,
Robin, how are you?
yeah, good, thanks. I heard on speaker. Look, just a quick question, John. The enduring power of attorney, I did have my will done, very uncomplicated sort of circumstances, but the will done as the public trustee.
Right.
And I'm just making inquiries about, I didn't put a enduring power of attorney attached to that. Is that a separate document?
Yes, it is. Yes. So it's a totally separate document. And of course, the power of attorney only has effect whilst you're alive. It immediately ceases on death. And at that point, of course, your will comes into play.
Right. So in the case of putting everything in order,
yes,
you would have your will. You
Yep.
would have appointed someone should you have a lack of capacity. Is that the way it goes? With
yes, but that would be but that would be under the power of attorney document, not under the will. So the will would only deal with your affairs once you've passed away, and the person who looks after things for you once you pass away is the executor of the will. The separate document would be the enduring power of attorney, and again you would appoint one or more persons to be your attorneys. Obviously, it needs to be people that you have complete trust in, and they would only be able to act during your lifetime. And once you pass away, their power to act on your behalf immediately ceases.
Right. So in the case of should something happen down the track and you don't have capacity, they can step in and close bank accounts that I was talking about earlier.
And otherwise look after you. They can organise for you to go into a nursing home if you need to go into a nursing home. They can organise care packages for you, all that sort of thing. All the things that you would normally do for yourself if you had capacity, they would then be able to do for you in your place.
Right. And just the last quick question. I did use the public trustee after hearing, I think, on one of the shows that they don't charge for just a simple will. Is that also something? Would you know that?
I believe they do, but all I would suggest you do is just simply make a call to them.
Yep, will do.
All right.
Terrific.
Okay,
Thanks
Robin. All the very best. Time 27.5 minutes past 9, and probably our last caller for today. A very good morning to Doris. G'day, Doris. How are you today?
Oh, good, thank you. Thank you for taking my call. I just wondered if you could tell me, I had a house in Mermaid Waters, and I sold, and I came into this granny flat on this house, and I put all my money into this house. I didn't keep any, and my name is on the deeds of the house, as you say. I wondered would I go on, like, if I have to go, to be looked after.
If you have to go into nursing care, into a nursing home. Well, a lot depends on the terms of the granny flat agreement that you have, Doris, as to what happens if you need to leave that property. So whether, I presume that you're in a granny flat arrangement with a family member, are you?
Yeah, I'm on the back of the house.
Yes.
As I said, it was an agreement, like, if anything went wrong, I would get my money back, what I'd put in.
Okay. All right. Well, if that's the situation, then presumably there would also be some arrangement whereby if you need to go into nursing care and it is necessary for you to pay a residential accommodation deposit to do that money would be released or the money you put in would be released to enable you to do that.
But how would I go on if they haven't got that money?
If you're on the title for the house, then you do have the ability to, if you wanted to, and it would be a very drastic step, to force the sale of the property because you are an owner, so you can apply to the court to appoint an agent to sell the property. But the other thing your relatives could do would be to take out a mortgage to raise the money so they can pay you out. The other thing you can do too is negotiate with the nursing home about what arrangements they're prepared to agree to, because depending on the level of your assets, you can actually get a placement in a nursing home without the need to pay the residential accommodation deposit. So probably what I'd be doing is just having those conversations with your relatives now about how that's all going to be dealt with in the if and when it's necessary for you to do that, so there's no surprises down the track. And you could even have a bit of a look around at some of the nursing homes where you think you might like to go and see what sort of arrangements they could put in place. All right then?
Okay, thank you very much.
Okay, Doris, all the very best.
Thank you, love. Bye-bye.
And thank you to all the people who've called in to make for such an interesting program. I'll look forward to being back with you, of course, next week for another program. But until then, it's as always, this is John Fradgley from the Bell Legal Group saying goodbye and God bless.